Everyone, and welcome to our weekly town hall, where this week we're continuing our what to do during the recovery period. So thank you for joining us today. As always, this is open for both members as well as non-members, free of charge. We want to keep our community as informed and up to date as possible. So we're glad you could join us today. Next slide. Just as a reminder, these are weekly, and next week we will be, our speakers will be discussing, what is different about buying and selling businesses in the COVID world. We do see a lot of activity going on. There's a lot of money looking for businesses, and people are deciding, what am I going to do in the post-COVID world? So some things to think about if you're in that position. The following week, we are going to discuss tax issues for employees, not employers, around the working virtually. So these range from if I'm in a high tax jurisdiction, what it means to me if I'm working virtually, what if it's required versus voluntary, and what type of tax benefits are there for employees not working virtually. So hope you can join us. We have a couple of tax experts joining us for that session. We do have a couple of more signature events coming up on October 7th, and I'll talk a minute about that Diversity, Equity, Inclusion Symposium. And then October 30th is our Total Reward Summit, where we will take the lens of the new normal and look at what to expect next year for benefits, compensation structures, culture, what should we be thinking about as we look to get the most out of our workforce through culture and the ROI with that. And then on December 10th, we will be doing our business trends event, which is normally done in January with Joel Naroff, where we also release our business trends results, which we're in the middle of surveying right now. So Joel will be joining us, but we'll also combine that with Mike Trackman discussing the HR kind of regulatory and compliance implications of whatever happens with the election. As we know, that's a big topic, then sure to have an impact that we'll discuss at that point. So I hope you can join us for that. That event will be free for members, and I can't remember if it might, actually, if you participate in the business trends survey, it's also free for you. So after the event today, we'll send out the link for that. Please participate because we'd love to get as much information as possible, but also get you free attendance for that session. Okay. So again, we're, I'd say the two drivers of kind of what everyone's thinking about these days are COVID and diversity, equity, inclusion. So this is a wonderful event that's coming up in 2 weeks, where we have speakers talking about, not just what it is, but kind of things to be thinking about as you look at your organization. So we have very reasonably priced this 4-hour event at $100 per person. If you do this event along with our Total Reward Summit, there's further discounting available, which we'll let you know about. So again, I think a lot of us are in the awareness and understanding phase, and I think this is a wonderful chance to listen to some great speakers discuss diversity, equity, inclusion. So I hope you can join us for that. Okay. So as always, we will wrap up the day with Amy discussing all things COVID and legal. And again, there's a dynamic space. But our first speaker today is one of our strategic partners, Rebecca Rakowski from Xpan, which is a niche law firm that deals with technology issues. And again, part of the new normal is our workforce no longer working in our control physically, but at home, and what that means from a privacy and security to our businesses. So let me turn it over to Rebecca.
Great. Thank you so much, Kevin. I am going to share my screen and my slides for everyone. And hopefully you are all seeing my slides. I'm speaking today about privacy and security in the time of COVID. And I think one of the important things for us to note is that we are all operating remotely, and we are experiencing this new normal. Eventually, we're just going to call it normal, but it's new normal for right now. And I was speaking just the other day, and I said, well, we have two realities, BC and PC. So before COVID and post-COVID. So as we're moving post-COVID and living and experiencing life in this more remote environment, as Kevin said, we are more and more heavily relying on technology. And so with the goods come, or the sweets come the sour, so to speak. And so as we have transitioned, and we are operating our businesses in the world of COVID, I think it's really important that we take a look at your privacy and security aspects to make sure that you are complying with the laws and that your contracts and agreements are shored up and as tight as possible, so that you can be moving forward confidently within your organization. So part of working remotely requires a lot of considerations. And when, I don't know about the rest of you, but it was basically March 13th for me and for my family. When March 13th happened and we were experiencing this transition, there were four main things that every organization needs to consider. And while everything happened quickly, now we need to go back and make sure that everything is shored up and like I said, that we are putting our organizations in the best possible position. I think people need to stop talking about just surviving COVID, and I don't mean the disease, but surviving what it means for business, but thriving. And it's totally possible to thrive in this environment. And I have a lot of clients that I speak with regularly and that I work with who have talked about the fact that they're not going back. This is going to be there forever because it is a lot easier to work remotely. It's a lot less expensive and it's doable. And we all, before COVID, people were like, oh, remote, you work remotely. My law firm was always remote. And so I think that organizations have now woken up to the fact that they can do this. It's important that we recognize that there are going to be changes to the business and the processes that flow from this. So the first thing I want to talk about are this puzzle, so to speak. So we have regulations, we have contracts and agreements, we have the technological infrastructure, and we have documentation and training, which all needs to be considered as we're moving forward in a PC environment. And the first thing to consider, the overarching thing, and one of the reasons why I always like talking with benefits or HR individuals is because they get risk mitigation. Their whole world is risk mitigation. Every aspect of their lives deals with mitigating risk. So each one of these pieces to the puzzle, if you fit them together correctly, will assist you in risk mitigation. So some of the regulations, and again, people who are in benefits and in HR are always keenly aware of things like HIPAA, the Health Insurance Portability and Accountability Act. So these are laws that need to be considered. And now that you have transitioned, you need to go back and look at your policies to see if there needs to be changes to correspond with the way you're now functioning as a business. Do there need to be tweaks and alterations to your HIPAA policies and procedures because you're not sitting in a office space anymore, but you're working remotely? And so it's really important for you to think about these types of things. The next one is FERPA. So this is the Family Educational Rights and Privacy Act. These are just a few regulations that we see it being altered. And two that I think are really important, especially when you're dealing with HR, is the EU's General Data Protection Regulation and California Consumer Privacy Act of 2018. So both the GDPR and the CCPA, the GDPR applies to employee-related data. The CCPA does not yet apply to it. the good people in the country of California, and I joke because it always seems like it's its own standalone country, they are considering a new addendum to the CCPA, which may actually push back the applicability of CCPA to employee data. But rest assured, it's coming to a theater near you. And so it's really important that you consider this, particularly from HR, because if you think about it, now that we're in a post-COVID world, you could be hiring people from other parts of the country. I was on a call this morning and we were talking about the fact that we are no longer limited to our zip code anymore. We're no longer limited to our immediate geographical physical area around us. We now have the ability to hire and use vendors from all over the country because we're all experiencing the same thing at the same time, which is having a more remote workforce. And so with that, you need to consider the laws that correspond. And each of these laws has significant impact in benefits management, in HR. And so considering where, and I'm not telling you like don't hire people from California, I think, because of the CCPA, right? What we want to do is you want to consider that this may be adding to some of the constructs around which your business is formed. And so it's very important that you consider this as you are dealing with this new normal and adapting to the regulatory structure that is around, you know, that exists around what we're doing today. So a couple of things, because everybody thought, especially in the beginning, that we didn't really need to worry about regulations or laws because of COVID, that these state and federal organizations would not be enforcing those laws. They were basically saying, well, you know, we're all dealing with this insanity and this is the last thing we need. And so we don't have to worry about things like HIPAA privacy and security rules and GDPR and CCPA. They're not going to bother us during COVID. Well, in fact, that is not the case. The Office of Civil Rights has not stopped in their enforcement actions. And in fact, they issued a statement back, I believe in February, that just because we are living through a health crisis, a public health crisis, that does not mean that the privacy rules are suspended. It in fact means that they're more important than ever. So ensuring that from a benefits and from an HR perspective, that your employees are not taking a laissez-faire or devil-may-care attitude towards the HIPAA policies that you have in place is really important, because if you violate those policies, it is very clear that these organizations are going to, in fact, have something to say about it, these regulatory bodies. So this was a statement that was the EDPB, which is the European Data Protection Board, also issued a statement in light of the COVID outbreak, reiterating the fact that it is more important than ever that we have these privacy and security rules in place. And lest you think that we are, you know, that Europe is somehow different, we just saw the introduction by a group of Republican senators of a federal data privacy bill. Now, this is one of, I don't know, 30 that have been proposed in the past year, but privacy and security are becoming heightened issues for organizations. There's certainly heightened issues for government. We see hackers trying to infiltrate, particularly nation state actors trying to infiltrate governmental organizations all the time. But the government is recognizing more and more that while we have restrictions on the privacy, not a right in the United States in any way, shape, or form, but privacy is something that it is something that has become a lightning rod issue for a lot of organizations, because there's nothing that addresses privacy from a non-governmental perspective. In other words, companies are free to go out and basically unless you're in healthcare, unless you're in finance, unless you're in California, there aren't a lot of restrictions around the sharing of data. Well, that's not so in Europe, and that's what we see with the GDPR. And so it's really important that you are considering, as you're living in this post-COVID world, that these new that the laws that are on the books in certain jurisdictions may apply to you, and they are in no way, shape, or form suspended. So continuing to comply and updating things in order to comply is going to be really critical. Oops, sorry, wrong direction. And so, no, I was going in the right direction. The European Data Protection Board went, in addition to its notification to organizations that it wasn't suspending GDPR requirements, they also talked about processing healthcare-related data for research purposes in the context of COVID. They went through and adopted a variety of different provisions regarding the sharing of healthcare data. So we see that for countries and for the European Union, they are very clearly working towards having privacy apply even in a post-COVID world. One of the things that is really important is that because Europe has a data privacy law, that sharing things like contact tracing and stuff like that is not as big of an issue for the European citizens as it is domestically here. It was interesting. Yesterday, I was on my town's Facebook page, and I noticed that they were talking about one of our schools having a case of COVID. And somebody said, well, you're lucky to even get this information because it's HIPAA data and they shouldn't even be sharing this. And of course, I got my hackles up because they're absolutely wrong. It's not HIPAA data because the school district is not a HIPAA covered entity and therefore does not have the same confines that a covered entity or a business associate would have. So another tip that I would give you, particularly in HR and benefits, is to make sure you really understand what role you're playing in the data transaction, particularly as you go forward, and there may be additional requests made of you about healthcare related data. Just because it is healthcare data does not mean that you are confined by HIPAA. In fact, you may not be constrained by HIPAA because if you're not a covered entity or a business associate to a covered entity, HIPAA does not apply to you. I can go and stand on the street corner and yell about my husband's medical conditions. He doesn't really have any, but if he did, and that's not HIPAA. That has nothing to do with HIPAA because I'm not a covered entity and I'm not a business associate. And so you really have to understand that role. And one of my biggest pet peeves is organizations that take on the obligations of HIPAA without actually being a business associate or covered entity. And so you have to be very careful regarding those types of things, particularly in HR and benefits, because you guys are the ones where they usually look and go, well, look, you've got all this healthcare data. Well, you could have healthcare data, but just because you have healthcare data does not always equate with I have HIPAA. You need to perform the analysis to understand whether or not HIPAA impacts you. And what that means to your organization. And I say this now talking in a post-COVID world because if your organization has maybe part-time workers in the building and there is a COVID outbreak, you may be asked to provide information. You need to know how to do that. The only way you know how to do that is if you know what laws apply to you and how those laws work. And so I always suggest to people not to just, guess or make an assumption, but to really look into it and perform and have an analysis performed, have a privacy and security assessment performed on your organization, because that is the only way to truly understand how these laws are impacting you. And so we are, I just want to talk a little bit about some other jurisdictions that we have, and I apologize if you can hear my son ran in here and asked me a question, but I gave him dirty mommy look and he left. So I am also working from home and my children are remote learning. So I'm sure everybody is experiencing, this is our life. These are our lives. And so, but my point being, you really have to understand things in order to understand how they impact you. I once had a client say to me, I don't know what I don't know. I'm like, well, that is kind of a really weird way of saying that, but he was right. And that's what he said. He goes, it scares me that I don't know things. And so we want to make sure that you guys are well informed so that you can then turn around and make the best possible recommendations for your departments and for your employees and ultimately for the organization as a whole, so that, as I said before, you continue to thrive in this environment and not just merely survive. So one of the big things that we are facing domestically in terms of privacy laws is the California Consumer Privacy Act, or the CCPA. And so the Attorney General, okay, I'm just going to stop for 1 second because I had someone ask a question, and it says, can you give a specific example of how a business can or should communicate COVID-related information to employees, especially as it relates to privacy? So one of the things I would say is, I don't know if I can give you a specific example, but if you're discussing things like if you have a COVID case, first of all, you have to make sure that you are not necessarily discussing with the entire organization that who that person is who may have COVID. You have to make sure that you are abiding by their privacy, right? You're respecting their privacy. However, it all relates back to what is in your privacy notice to your employees. Do you even have one? And your privacy notice in light of COVID should be updated so that your employees know and understand what they can expect to see if one of their coworkers gets COVID, because you can't not tell people that they've been exposed. And so it's really important that you go back and you re-examine those policies and procedures and your employee notices. Look at what laws apply to your organization. Unfortunately, giving a specific example is difficult because all of these things I'm discussing impact what you can and cannot do. When you have privacy notices to your employees, or you update those privacy notices to your employees, and we've been doing that a lot lately, is working with companies to update their employee privacy notices because of this, because of COVID. What we discuss with them is, we look at what are the laws that are impacting their business and see if any of those laws are impacting that type of data, and then we can go from there. But unfortunately, it's not just a one size fits all. It really is specific to a business. So the great question, and I probably should have said this at the beginning. I love questions, and I'm happy to answer any questions you may have. As Kevin said when we started this is supposed to be kind of an open discussion and forum. I'm discussing and going through my slides just to kind of give everybody a framework. But if you have questions, please type them in. I'm happy to answer them. So one of the things I want to talk about is the CCPA. Again, the California Consumer Privacy Act of 2018, it went into effect on January 1, and a lot of organizations thought that it wasn't going to happen because of COVID. They're like, oh, the Attorney General's never going to go forward with all of this. But in fact, the Attorney General from California issued a statement talking about the importance of consumers knowing their rights under the CCPA. It went into effect in January of 2020. Like I said, the employee data is not necessarily included in that yet, but it will be. And it's important that if you are impacted by the CCPA and there are there's an analysis. It's not just I have California data. There's actually an analysis around it that can be performed to determine whether or not CCPA impacts your business. It should be, you should be talking, HR should be a part of those conversations, because that employee data is going to be impacted by CCPA, whether it's January 1st of 2021 or January 1st of 2022. It's coming. And because it's coming, you need to start preparing for it sooner rather than later. Some organizations did a full scale, they just went soup to nuts. Some organizations thought, oh, well, it'll be better, we can just piecemeal it. That way, we don't have to do it all at once. But as a result of that, a lot of them carved out HR, but it's happening sooner rather than later. And unfortunately, we're not going to really know which way they're going to go until the election, because there's a new initiative on the ballot to increase protections around CCPA impacted data. So If your organization is not thinking about CCPA around its employee data, it's something you really should be raising with them. And another thing I would point out is that California is not the only game in town. People think that, like I joke around that it's this country of California, but the reality of the fact is data privacy laws are expanding and data security laws are expanding all across the country. We have California, like I said, has the CRPA, which is the addendum to the CCPA, which is being considered. But Hawaii, Illinois already has a biometric law on the books, and we see a lot of litigation and class action litigation coming from that law. And what's interesting is under the Illinois laws, BIPA, is that 9 times out of 10, it's not third parties or consumers, it's employees, because HR uses a lot of, or can use a lot of biometric data. It's interesting, one of my clients was actually sued under BIPA and because they had thumbprints for their employees. And we actually were able to show that it wasn't, the thumbprint wasn't a biometric, not under, as the law is written, and not technically a biometric, and they were able to get out on a motion to dismiss. But understanding that and having, being aware of that is incredibly important. Initially, everybody was like, oh my gosh, we're getting sued. But then when we realized what the suit was about and that the technology around the thumbprint recognition had nothing to do with biometrics, we were able to counsel them through that. And that's really important. Massachusetts is proposing a privacy law as we speak. However, people should be aware that Massachusetts has a security law as well. And because of that, you need to be aware that there has to be certain confines around the data that you are collecting. Particularly, Massachusetts requires organizations to have a written information security program, or a WISP. And that's around all of the sensitive data you are collecting. I think it's important to note that we are also starting to see a lot of movement with regard to state-specific lawsuits. In Pennsylvania, for example, there is a case on the books right now from the Pennsylvania Supreme Court, which is UPMC versus Dittman, D-I-T-T-M-A-N. And so with Dittman, and I think this is kind of responding to the question that was just posed, which was, can you provide any detailed information regarding PA privacy and security pending legislation? The answer is yes, and you can email me, and I'm also going to provide a little bit around security right now. So UPMC versus Dittman was a class action lawsuit brought by the employees of the University of Pittsburgh Medical Center that resulted from a data breach that UPMC experienced. And the Pennsylvania Supreme Court specifically stated that that an employer that is collecting sensitive data has an affirmative obligation or a duty, and I'm sure all of you know what that means, right? They created a common law duty around the protection of sensitive data. In other words, if you are going to require your employees to provide them with things like social security numbers and date of birth, address, information around children for beneficiaries under benefits plans and things like that, you have an affirmative obligation to protect that information. And so particularly in Pennsylvania, we now have this case. And what does that mean, an affirmative obligation? Well, it means that you have to be taking steps that a reasonable business would be taking to protect and secure that information, considering the sensitive nature of that data. And so and I will say this, similar to the medical field, privacy and security works like this. If it is not written, it is not being done. Right? If you do not document it, it is not being done. If you are not training your employees around it, it is not being done. If I take a deposition of your employees and I say, well, what is your policy regarding passwords? And they go, I don't know. That's a problem. Okay. You are creating an unreasonable, your employee, it's unreasonable that your employees wouldn't know what the password, that they have a password policy and what it is. Now, that doesn't mean that your employees have to know how your firewall is configured. That's ridiculous. But they do have to know how the policies and privacy and security policies affect them and their day-to-day job. And that's what's really important. And that's why when people talk, and I'm going to talk about training in a few slides, but that's why one of the big things that I always talk about is if you're buying an out-of-the-box, training on privacy and security like we do for like sexual harassment training and things like that, it's really not reasonable because because the way an individual uses a system and the way different departments use a system can really affect how privacy and security is impacting that data. And so a good lawyer with creative arguments is going to be able to basically cut right through that and say, well, this was nothing more than a rote exercise and it didn't really add anything in terms of knowledge to your employees. Pennsylvania does not currently have a privacy law on the books, although one is currently in development. And I know this because my law firm has worked on parts of it. The same being for New Jersey. New York is another animal as well. New York has the New York Shield Act. And the Shield Act also has affirmative obligations on businesses to take proactive security steps. And I will tell you this, that what's another thing that is, I find troublesome in this area with the way privacy and security is addressed is you need to be cross-mapping. So if you're being impacted by CCPA and New York Shield, the Illinois biometric applying with all of those and being able to cross map those and basically use the good practices you're doing for one law and apply it to another. And this is particularly important. The two biggest areas in which, or two biggest departments in which I always work with most, everyone says IT, right? Because you do privacy and security. Wrong. Finance and HR. Because you guys are the ones that have the data. IT is just making the ship run, okay? And yes, I work with IT very closely, but they're not the ones who they have the keys to the kingdom of course they do, they have administrative access levels, but HR and finance by far are the ones that have the most sensitive data and don't always understand where all the data is being stored. And so really important, particularly in this time, because are your employees downloading and storing things locally on their computers? Do they, maybe not so important before when they work remotely 1 day a week. Now, heightened importance because they're working remotely more than 1 day a week, right? They're working remotely regularly. So really understanding the data, how your employees are using the data within your department and what laws are impacted by that data is critical, particularly in an HR situation.
Rebecca, I hate to do this, but we are going to have to stop you at this point because we have to get up to our COVID legal, but we'll definitely bring you back for another session to there's so much covered here. So if anybody does have questions, if you want to reach out to the hotline, if you are a member, we can also, Jane and Amy can connect with Rebecca, who's one of our partners for our hotline and resources. So, but thank you very much. It's always a scary area, and you've done a good job scaring us even further about privacy.
Not sorry.
Yeah. All right. Thanks very much, Rebecca.
Thanks,
and
Kevin.
With that, we'll turn it over to Amy.
All right. Thank you, Kevin. Yeah, that was great, Rebecca. Okay, so just a few things to go over as far as our COVID legal update for this week. So this was breaking news last week, but I kept the slide up in case you didn't join us last week, because this was kind of a big deal, but it's yet to be seen exactly how big of a deal it's going to be and what the impact is going to be as we head into winter especially. So last Monday, a federal judge here in Pennsylvania ruled that orders by Governor Wolf to shut down businesses and limit gatherings to tackle COVID-19 were unconstitutional. Okay, so when we had the limitations on gathering sizes, when we had certain businesses shut down, a federal judge said, no, can't do that, which is interesting because the Pennsylvania Supreme Court recently had rejected a similar type challenge, so they decided differently, and federal courts in other states have reacted differently to the orders instituted by their governors. So to be noted, the federal judge was a Trump appointee, so definitely would be expected to have a certain political leaning. Now, the interesting thing is that most of the orders that were covered by the ruling are no longer in effect. Okay, so most businesses are allowed to operate at least to some degree. Even restaurants and gyms here in Pennsylvania are back open at least to some degree. But it will be very interesting to see. Now, first of all, Walt's office has said they're going to fight this, so there will be an appeal. But also be interesting to see if we move into winter. There is some prediction, right, that our numbers will go back up here in Pennsylvania. And if Governor Wolf wants to reinstitute some sort of a shutdown, it sounds like it's going to be a fight, even more of a fight than it was last time. So definitely stay tuned on all of that. Also an update on FFCRA, that's the Families First Coronavirus Response Act. Hopefully you're all familiar with FFCRA at this point. It applies to employers with 500 or less employees. And provides leave to your employees for a variety of reasons. But the biggest one probably right now is childcare, up to 12 weeks with some sort of pay for childcare reasons if the childcare or the school is closed due to COVID-19, or the childcare provider is not available due to COVID-19. So earlier this year, we had a federal judge in New York struck down certain DOL interpretations of FFCRA, and so the DOL updated its guidance. Okay, so a couple of things to take note. Employers don't need to provide FFCRA when no work is available. Seems fairly straightforward, right? If the employee is on furlough or the employee has been laid off, you don't have to provide FFCRA leave, but just confirming that. In that case, the employee should be eligible for unemployment benefits and not leave. But the big thing here, and I think the takeaway that the DOL was trying to get through, is the employer shouldn't elect to put someone on furlough because they request leave. Okay, as soon as someone requests leave, you have an obligation to work through that with them. You can't because they are requesting leave. Okay, I've got a couple of questions here around FFCRA. Someone's taking issue with my comment about the Trump appointee. I'm just stating a fact. I think that we know that judges tend to lean left and lean right. So I'm not trying to offend anybody with the comments, but we know that certain judges have certain political leanings. And I think it's fair to say that this judge probably has a political leaning in one direction. If someone requests FFCRA time due to their own COVID symptoms, do I need documentation from a healthcare provider? We do have the documentation you can ask for under FFCRA is very, very limited. We have a certification, sample certification on our website. So take a look at that. I can't remember exactly what you can ask for the COVID-19, but it would probably be a copy of a quarantine order from a healthcare provider. But there are other situations. If the employee simply is not feeling well and they're seeking a diagnosis or they're seeking testing, they don't have to get something from a healthcare provider. So keep that in mind. Okay. But like I said, there's a sample certification in member tools on our website, so take a look at that. There's a whole thing around intermittent leave. The federal judge in New York, this one, said intermittent leave had to be, there was took issue with whether or not the intermittent leave had to be approved by the employer. So the DOL is saying, well, yeah, it does have to be approved by the employer, but if you've got kids going to school in a hybrid model, which hybrid means they go to school some days in person, they go to school online other days. Each time they go, each time they're home and therefore the school's closed to them due to COVID-19, that's a new, that's not an intermittent request, that's a new request. Okay, so it kind of takes away some of the discretion on behalf of the employer with regards to a hybrid model of schooling. And I think that was one of the big concerns. But the DOL has also clarified that if the employee has a choice to send their children to school or to keep them home for distance learning, the school is not then closed to those kids for FFCRA purposes. And as a result, FFCRA is not going to apply. So something important as well. And then you may have seen this week, a lot of stuff going on with the CDC. Things are going on their website. Things are coming off their website. So this is the current guidance from the CDC with regard to testing. Okay, so I just pulled the two that I think were most important for employers' purposes, but there's a whole part of the CDC's website that talks about who should be tested and when. Okay, so if you've got an employee with COVID-19 symptoms, this is what they should be doing. Okay, mild symptoms, talk to their healthcare provider. Okay, whether or not they should test. If there is a positive test or there is no test, the ultimate decision is made not to test. The individual should self-isolate for at least 10 days after the onset of symptoms, and resolution of their fever for at least 24 hours. And that's without using fever-reducing medications, okay? So no Tylenol, no Advil, no aspirin, and with improvement of other symptoms. We've seen that phrase before, improvement of other symptoms. What exactly does that mean? It's a little bit subjective, but that the person's on the road to recovery. A negative test is not required to have someone to return to work or to school as long as they weren't hospitalized. And again, at least 10 days after symptom onset, resolution of fever for at least 24 hours without the use of fever-reducing medications. And again, that improvement of symptoms. And then what about, you've got individuals with no symptoms, but maybe they've had an exposure. What does exposure mean? According to the CDC, if you've had someone who's been within 6 feet for at least 15 minutes of a person who's known to have the virus, okay, you should get testing, all right, even if you're not having symptoms. And then self-quarantine, isolate at home pending the test results. Even with a negative test, self-isolate for 14 days because we know there is an incubation period, right? You may have been tested before there was enough virus in your system to have a positive test, or there are false negatives as well. In some situations, self-isolation is not possible. I'm talking about critical infrastructure workers. Wear a mask, physically distance, avoid crowds, wash your hands, don't touch your face, and monitor for symptoms. But there is more on the CDC's website, and so I think I've been telling you guys this since March. If you ever have an extra 5 minutes in your week, go on the CDC's website, troll around, take a look, because there's always new stuff being put there. And then another big question that we're getting a lot of, and then I'll do some questions. What about the flu vaccine? And what about when, you know, fingers crossed, we have a safe and effective COVID vaccine, hopefully early next year. So under the ADA, employers can establish legitimate health and safety requirements that are job-related and consistent with business necessity. In the past, we've seen that healthcare providers, you know, hospitals, doctors' offices, anyone who's having contact with the public in a healthcare setting, those employers have required flu shots, right? And they've mostly been upheld under the law as being allowed to do that as long as they allow for reasonable accommodation under the Americans with Disabilities Act and under Title VII for religious purposes, okay? What EEOC is telling us now is, you know, it may very well be that many more of us as employers now have a good business reason for asking our employees to get flu shots, right? Especially now, if we're all working from home, maybe not so much, but if your employees have contact with the public, it starts to be a more compelling argument that they should get flu shots, and certainly a more compelling argument that they should get a COVID shot if and when that becomes available. And there's a big but here, though. And I think two things. Obviously, you've got to think about your reasonable accommodation if employees ask for something under ADA or Title VII. But the other one is really think this through before you implement any kind of a policy around mandatory vaccinations. What are you going to do if the employee out and out refuses and they don't have a medical reason, they don't have a religious reason? Are you prepared to fire people? And if you're not, and I think most employers are not, then don't even put the rule in, because there's nothing worse as an employer that you put a rule in, you say, this is the law of the land, your employees refuse, and then you have to backtrack. So instead, here's my suggestion. Strongly suggest to your employees that they get a flu shot and then the COVID shot if and when it becomes available. Make it really easy for them to do that, right? Can you do some sort of a flu testing or flu shot that comes into your office? So I know all of the big pharmacy chains will come to your office and they will do a day of flu shots for your employees, or multiple days of flu shots for your employees, if that's what you want. Or can you give them, everybody, an hour, you know, to go, an hour, paid hour go get your flu shot during the workday, fine with us. So I would probably err more on the side of strongly suggest, make it easy rather than making it mandatory. Okay. I did see we had some questions come in. What would happen to an employee if they exhausted the 12 weeks of FFCRA for childcare between April and June, but now have issues again? Great question. If someone has already exhausted their 12 weeks under FFCRA, or if they have otherwise exhausted their 12 weeks under FMLA, the time has run out, okay? You as an employer no longer have a legal obligation to accommodate those folks. You may, however, still want to work with people in some way, right? But that's something you need to think about. There has not yet been, I have not yet seen anything that suggests that Congress is going to extend FFCRA. Right now it's set to expire December 31st. But I wouldn't be surprised, especially if we go into more lockdowns, if schools are not open in January, that we see this revisited, okay? I'll take one more. If a doctor releases an asymptomatic person with a negative test prior to 14 days, what do we do? I would still follow CDC guidance. I think it's probably the safest thing that you can do. You know, I always think you can't go wrong as an employer if you follow CDC guidance, you follow your Department of Health guidance. You really want to make sure that we're getting the best possible information and relying on that best possible information. Okay. We do have more questions coming in. What we're going to do, since we've run out of time, we're going to capture those questions, and I'll take them and I'll use them in an FAQ next week. Okay. So please join us again next week. But thank you guys so much. Again, you've got to see my last slide here. Remember to visit the Coronavirus Resource Center. We're actually in the process of updating it right now. And continue to reach out for the members, continue to reach out to Hotline, continue to reach out to Member Legal Services. We are here to help. So I hope everybody has a great week, and we'll see you next week. Thanks.